Good afternoon, everyone. Chamber of Progress is honored to welcome you all to our press briefing today on the recent social media litigation that we heard in the Supreme Court today. I'm Jess Miers, Senior Counsel for Chamber of Progress. Chamber of Progress is a tech industry coalition devoted to a progressive society. We back public policies that will build a fairer, more inclusive country in which all people benefit from technological leaps. While our partner companies are parties to the lawsuits, while our partner companies have a stake in these lawsuits that we'll discuss today, Chamber of Progress and our views do not represent our partner companies, nor do our partner companies have a vote or veto over our positions. Here with me today are lawyers and experts who have closely followed these cases and thought deeply about their implications. Vera Eidelman. Vera is a staff attorney with the ACLU's Speech, Privacy, and Technology Project, where she works on the rights to free speech and privacy in the digital age, working on cases defending protesters, youth online speech, and genetic privacy. She has litigated prominent First Amendment cases around protest and book censorship, has represented plaintiffs before the Supreme Court. Thank you so much for being here. Larry Walters. Larry is general counsel at the Woodhull Freedom Foundation. He also heads up the Walters Law Group, a preeminent law firm concentrating in internet law, intellectual property, gaming, and First Amendment issues. Mr. Walters has developed a passion for protecting civil liberties, in particular, online speech and expression. He has devoted over 30 years to defending constitutional rights and protecting free expression. Mr. Walters is an accomplished civil rights advocate, a widely published author, and a well-known public speaker. Thank you so much for being here. And then we have David Greene. David Greene is a senior staff attorney and civil liberties director at the Electronic Frontier Foundation. David has extensive experience litigating First Amendment issues in courts, serving and steering advisory boards of free speech organizations, teaching law school courses on the First Amendment, and lecturing and writing extensively on free speech law, including as a contributor to the International Encyclopedia of Censorship. He has worked for organizations like First Amendment Project and National Campaign for Freedom of Expression, defending freedom of artistic expression, helped found the Internet Free Expression Alliance, and his work has been recognized through awards including California Lawyer Attorney of the Year in 2013. And thank you, David, so much for being here as well. During the first half of today's briefing, I'm going to ask some questions of our panelists, and then during the second half of today's event, we'll turn to audience questions. Before we start our panel discussion, I'm going to kick things off with just a little bit of background on the cases we're discussing. To quickly recap, the Moody v. NetChoice case and the NetChoice v. Paxton cases, the Supreme Court is set to decide whether Florida and Texas's content moderation restrictions comply with the First Amendment. The cases involve a challenge to Florida and Texas's social media laws, which the court is considering in combination with similar laws that were with similar discussions around the disclosure laws as well in these two laws. This includes provisions related to content moderation, individualized user notification requirements, and at stake is the constitutionality of the Florida law and the extent to the Florida and Texas laws and the extent to which states can regulate social media companies' content moderation practices under the First Amendment. It's no exaggeration to say that the future of free speech on the internet and whether user-generated content will continue to exist online hangs in a balance before the court today. So let's go ahead and dive in. So first question, I'm just going to really kick it off here. What is at stake here? Why are these cases so important, and how important is it that the court gets this right? And David, you're the first I can see to the left here on my screen, so I'm going to start with you.
Yeah, thanks, Jess. There's a lot at stake here, and if the court would uphold these laws and reject the argument, the core argument that NetChoice is making on behalf of the social media companies, which is that they have a First Amendment right to edit and curate the user speech that appears on their sites. If the court rejects that argument, that really opens up social media for a lot of and potentially unlimited amounts of regulation, of regulating the content on their sites. This is really clear because we see what Texas is doing in their law is really an attempt to require them to carry certain viewpoints. That really is almost the farthest reaches of what you'd see on a law in First Amendment land. And so once we take the First Amendment out of this, we're really opening up to a lot of regulation.
Lawrence, I'll go to you next.
Yeah, I think you said it well that, the fate of free expression on the internet is largely at stake when you have various state governments here, Florida and Texas, attempting to impose what could become, a hodgepodge of just inconsistent, burdensome regulations on global internet social media companies. And on the more granular level, there's the issue of whether these editorial functions by social media companies are in fact protected by the First Amendment, and these cases give the court really the first opportunity to make clear what the lower courts have generally held, and that is that these editorial functions, the way that a news feed is presented, the way that information is curated and displayed to users is a traditional editorial function and protected by the First Amendment. So this will give the court a good opportunity to reinforce that, hopefully set that in stone from a First Amendment perspective. Based on the arguments today, there could be some other issues that the court veers into as to whether or not these expressive activities by social media companies constitute speech of the social media companies in part under Section 230. There was a lot of back and forth on an alleged kind of inconsistency where some of the justices were saying, well, how can this be First Amendment protected speech on the one hand, but not speech of the social media companies, at least in part, for purposes of Section 230 immunity on the other. So I think there's a possibility some Section 230 issues could be implicated here, which could have significant impacts if they are addressed. But overall, this is a critical set of First Amendment cases that will set the stage for the rules that tech companies have to follow going forward.
Thank you so much. And then Vera, any last minute thoughts there?
I think, yeah, it's basically just a choice between moderation by private social media companies and censorship by the government. And I think as reflected by a variety of the hypotheticals and specifics discussed at argument, there are ways in which both are unappealing, but the government option is surely worse, and it's also unconstitutional.
Excellent. So moving on, I would love to get each of your observations of how the arguments went down today. I was live tweeting both cases very quickly. I came to the conclusion personally that, I know the court was wrestling a bit with a lot of the particulars of the law, but to me, it seemed like the court really understood and appreciated kind of what's at stake here, the business models of these internet services, and most importantly, really understood that the laws that are proposed in Texas and Florida are constitutionally defective. David, I'll kick it over to you. What were your observations?
Yeah, so a few observations. One is I think we should all be happy that this is really the first online speech argument that I can think of where the justices haven't at some point talked about how they don't understand the internet at all. And so we've come that far now with whatever it took, 100 amicus briefs in this case, where they actually feel like now that if they're going to take these cases, they can't then complain that they don't understand the technology. So we should be thankful about that. What I think we saw today was several of the justices, I think a good chunk of them, expressing a lot of concern for the constitutionality of these laws with respect to social media platforms, and then being a little uncertain how to deal with to the extent that these laws may apply to other types of online services that aren't social media companies, and thinking, how are we going to deal with that? Is that something we have to address in these cases? Is that do we say anything? Do we say nothing? And to the extent that there was uncertainty among the justices, that's where I saw it playing out, and a lot of that has to do with the posture of the Florida case, which seemed to really trip up a bunch of justices, where it's presented as a very, very narrow issue about the First Amendment rights of large social media platforms to curate content. But yet the law does a lot more than that, and the justices seemed uncertain of how to deal with that. And even with Texas, the Texas law, they seemed to be wanting to be at least careful that they didn't speak beyond to other services. And so I think it'll be really interesting to see how the court does that. But I think there was a lot of the justices were really working from the assumption and accepting the core issue, the most important issue, which is that these platforms, when they platform users, when they deplatform, when they prioritize some content, when they recommend other content, when they choose not to publish something, where they choose to obscure something, that they are exercising their First Amendment rights to curate their services.
Absolutely. Lawrence, I'll go over to you.
Yeah, I think David had it exactly right. I was very happy to see the level of preparation and familiarity with the workings of social media companies and the broad scope of services that these companies provide, kind of the nuances of the difference between a news feed and direct messages and email. That hasn't been our environment that we've been litigating in for a while. But fortunately, judges and justices now are becoming more familiar with how the internet works and how online media works. And so I think that was very helpful to see that level of preparation. Where I agree that the justices struggled was with the level of factual development in the record, particularly in the Florida case. Both sides were blaming each other for why that happened. Whether it was the breakneck speed of the litigation, trying to get it up to the Supreme Court on a preliminary injunction, or whether it was one side didn't want to take discovery, and which constitutional arguments were pressed, and how the case was narrowed. So there were a lot of reasons why the case went up quickly, but that also left the court in a position where it didn't have a lot of factual record to evaluate exactly what services are provided, what do they all do, can some of them be treated differently than others. But I think David is right that the court had significant concerns with the scope of these laws, with the compelled speech components, with some of the vagueness of the requirements of consistency, et cetera. So I think the states are going to be in a little bit of trouble here. There may be a path forward where the court could try to get a more factually developed record by perhaps keeping the injunction in place. We keep our fingers crossed on that, and yet sending the case back down to the trial court for further development of the record and depositions and so forth, and then taking another look at it once that's done. But it seems like there is quite a bit of information in front of the justices here, just based on the facial prohibitions of the law and the requirements of the law that are so wildly inconsistent with developed First Amendment jurisprudence. I think that they could render a substantive ruling on the merits without sending it back. But we have seen other similar cases involving First Amendment issues kind of go up and down a tortuous path as the courts want more and more information before they make these critical decisions. Thinking back to the Child Online Protection Act cases in the early 2000s that went up to the Supreme Court and back down and up to the appellate court. So that is a potential path that this case could travel, and I think the justices really wanted to explore what all their options were before rendering what could be a historic landmark decision.
Absolutely agree. And then Vera, to clean up.
So, echoing some of the things that have already been said, I think the focus on function and not just entity was promising to me. And I think that the engagement with analogies, but also why the analogies actually matter was good, because I think a lot of the coverage of this has been, are they newspapers? Are they a shopping mall? Are they a law school campus? And I don't actually think that's the question. The question is, do they have the First Amendment right to curate content, and does this law violate that right? And I think the justices did a good job of honing in on that question. And on the breadth of the laws, yes, I agree that was certainly a focus of the questions. I think it would be great if the government knew what it was regulating and the breadth of the laws that it was passing. And I am hopeful that the justices heard the Solicitor General's and NetChoice's arguments about why it would be so dangerous to vacate the preliminary injunction, even if there are some factual questions about that scope.
Yeah, I specifically appreciated hearing the justices sort of reject a lot of the offline, online distinctions here. I think we really saw that with Justice Barrett, who she really recognized, like, they're not telephone companies. This is not the telegraph. This is the internet. It's a unique medium for human communication. So completely agree with you there. Lawrence, I'd actually like to go back to you. You mentioned an important point about how the court was really trying to tease out sort of the different services and how we could apply the First Amendment differently. And so I was curious to get your take on this email direct message distinction that the court was really trying to tease out from, say the social media feeds aspect. Did you have any thoughts on that?
My guess is that that issue was coming up in connection with trying to vet the argument as to whether or not these social media companies could be treated as common carriers or public accommodations, where they're not actually presenting any speech of their own. They're not curating, they're not changing the tenor or nature of the speech, or whose feed shows up on top or which one's more popular. Instead, they're just merely transmitting a message from one user to another, or perhaps from one user to a group of users. And in that case, there's a consideration of whether or not they should be treated differently, perhaps as some sort of common carrier for those types of services versus a more traditional newspaper type of presentation of information, or the news feed that we've come to know in social media, Facebook, Twitter type feeds. And so I think that is largely how the issues were coming up, and the court had to deal with the claim by the states that these are just common carriers and the First Amendment doesn't apply. We can actually do anything we want to them. And that seemed to catch a couple of the justices off guard, saying, well, okay, even if they are common carriers for certain purposes, and we're not acknowledging that, but that doesn't mean everything that they do has to be treated as a common carrier. And so, they, again, we're well aware of the breadth and scope of the services provided by these different companies, and how some, may trigger different First Amendment concerns than others. But I think it's the conduit issue, the common carrier issue that fed into that discussion.
Absolutely. Vera, I'm going to turn back to you. Should the government play a role in regulating online speech? It's a little bit of an existential question, but is there any role here?
I think it's good to think back on the history of how the government has responded to new mediums in general. This isn't the first time that also it's funny to talk about the internet as a new technology, but this is the way that courts and lawyers work. Every time that there has been a new medium, there have been concerns in society that it's somehow bad for society in general, for democracy, for kids in particular. And there has been a reaction by legislators that moves them to try to regulate the interactivity of the medium itself, the content, and that is almost always, if not always, the wrong answer. That there is a serious danger to regulating content, to limiting what people can say online. But that's not to say that there's nothing that the government can do. That's not to say that social media companies are off limits because they engage in the practice of making content available online. As the Solicitor General said at argument, I'm shocked that I am echoing her, there are any number of regulatory efforts that could actually get at some of the problems that exist with respect to social media, from antitrust to comprehensive consumer privacy regulations.
Yeah, I thought that was a really important point, especially since we've seen a couple briefs in favor of the Texas-Florida laws that had said, look, if you don't allow these laws to go through, then there is absolutely no way in which the states or the federal government will be able to regulate social media. And I think today's argument, and Vera, the remarks that you made here, I think it really goes to show that this is a pretty narrow question, and it does not set up that sort of environment. So moving on to the next question. David, this case sets an important precedent, but what other legal challenges or issues are poised to impact the way we communicate online? There's a lot going on.
There is a lot going on. These two are 2 of 5 cases dealing with various aspects of government's role with social media that the court is hearing. This year, it heard the first 2 on Halloween, dealt with the court's role as a user of social media with the government's role as a user of social media when government officials and agencies actually have their own social media accounts, and to what extent can they control public participation in those accounts, or the interactive spaces of those accounts. So can they moderate comments? Can they block users? And so that was the issue that the court heard argument in 2 cases on Halloween, and then coming up next month in 3 weeks, we have the next one in the Murphy versus Missouri case, which will deal with the role of government trying to play content moderator with the alongside the platforms. To what extent, does the government cross the line of acting as censor when it encourages, urges, or even simply notifies social media platforms about user information that the government doesn't want to see or wants to see de-emphasized on the sites. So, all these 5 cases certainly have the potential to tell us a lot about government's role, both as a user of social media, as a regulator of social media, and then as a partner with social media companies in terms of content moderation. The caveat is that we always say this with cases every year, and then sometimes the court issues opinions that dodges those issues. And I think a lot of people, I was in the courtroom today, and there were a lot of people who were grumbling that, oh, we're going to get a decision that has nothing to do with social media, but it's all about the procedures of facial challenges. I hope that doesn't happen. The court, I think, has put a lot of time into trying to learn these issues, and I think it would benefit all of us to actually have a decision and to learn something about these things. It's social media, as you said, it's not new. And these are not the only regulatory efforts, and there's a lot actually happening there. There are a lot of cases pending in the lower courts that are really waiting for this court to rule and clarify some of these very basic issues.
And I'm not going to let you off the hook yet, David. You brought it up, the Murphy case. Justice Thomas asked a couple questions that really started to go down the Murphy line of questioning. How is the court supposed to reason these 2 cases or square these 2 cases, right? If the court decides that the government was interfering in Murphy, surely then creating a law that directly interferes with content moderation should also be problematic. What do you think?
Well, yeah, and the interesting, I think, thing here was that Justice Thomas specifically asked this question of the Solicitor General, who's going to be defending the Biden administration. They're the petitioners in the Murphy case. And so I think that Justice Thomas, was interested in what he perceived to be an inconsistency, that here you're telling the states that by statute they can't interfere with content moderation, but it's okay for your client, in 3 weeks you'll be arguing that it's okay for members of the executive branch to do so. I don't see the inconsistency, because I do think it's wrong. I appreciated the Solicitor General's response, which was in the Murphy case, the question is coercion and where we draw the line at coercion, and at what point does the government's interaction with social media companies essentially take over their content moderation process. And that's sort of that's the question that the court has to flesh out in the Murphy case. Whereas when you have legislation, that's not a question. We're already at the point of coercion, and then the question is the coercion unconstitutional? So I think that was the way squared it, but clearly Justice Thomas was at least trying to poke a little bit to see if there was an inconsistency in the positions.
I absolutely agree with that. Lawrence, over to you. So we heard a lot today about what's going to happen if the court decides to not affirm the preliminary injunctions, or if they do affirm the preliminary injunctions. I think the Texas attorney had even said, the other side is coming up with, quote, vile hypotheticals. What say you? How do you think the companies will respond if the justices decide that they will not affirm the preliminary injunction? Will the internet become a wasteland or a cesspool?
Well, there was some discussion about that, particularly with the Texas AG, as far as the option to simply pull out of Texas. They wanted to do that, but then NetChoice and the social media platforms looked at the restrictions and concluded the wording of the prohibitions are such that you couldn't even pull out of Texas completely, that you couldn't discriminate against somebody who is geographically located in Texas. And so that left them in this catch-22 of, we can't avoid these restrictions, we can't comply with them without significant burden. We have to display something completely different to Texas users and have completely different rules as far as termination and consistency and changing our terms for Texas users. So it would be, I think, mass chaos if the injunctions were vacated and the states were allowed to enforce these rules. How the platforms would address that, if they would, or the full nature of the compliance efforts are are yet to be determined. There was some discussion of, well, maybe we can, just only show puppy videos on Florida or Texas feeds and, try to comply for a short period of time, at least until we can litigate this case further and bring it back up to the Supreme Court. But I think it would be very dangerous ground to allow these laws to go into effect, either Florida or Texas, and it would result in significant damage to both the companies and to the user experience on the websites that are affected by the laws.
And Vera, could you speak to some of the ramifications potentially for users, depending on what the court decides?
I think if these laws are allowed to go into effect, it would either be chaos or basically nothing on the internet. I think it would mean that there is no curation. It's kind of impossible to work through a social media feed because I guess one of the options is first in, first out. I don't really want to see what that would look like. Or it would mean just offering basically, puppies all day, which isn't the worst thing in the world, but it's pretty limited. And I think, as David pointed out before, if these laws can go into effect, depending on the reason, I can't imagine a logic that would allow these laws to go into effect that wouldn't then open the door to any kind of government regulation of what's on social media.
Excellent. I'm going to ask one more question before we turn to audience questions. This is for everyone, and David, I'll start with you. What the heck was going on with Section 230 today? Isn't this a First Amendment case? Why were the justices so keyed in on Section 230? And what do you think, if anything, what implications will that discussion have on the court's decision?
Well, I hope it doesn't matter at all. That being, and the reason I say that because these aren't the cases to really dig into 230, and the court keeps on taking. We had the court with its false steps last term, thinking they found the cases to dig into 230, and they didn't, and so they didn't address the issue. And the way these cases are presented, I think, would be a bad idea too. I think there were two things happening with the questions that were being asked of Section 230. And I think one set of them reflects just a common misconception or purposeful ignorance about how 230 works, or that it somehow requires or is based on some promise of neutrality, which is completely the opposite of what it does. Section 230, as all of us on this on this panel know, was designed to make the question of neutrality irrelevant. And so there was one set of questions that sort of really dealt with, like, oh, they're being hypocrites. They say they're neutral and they got this benefit because they're neutral, and now they're telling us they're not neutral. So the other set of questions, I think, was actually a little bit more nuanced, and I think really plays into an issue that the lower courts have been battling around a bit, which is to the extent that Section 230 allows for liability. So there's no immunity if the online service, including here social media platforms, play a part, are a creator in part of the harmful content. And if the curation, the compilation, and the recommendations, and the amplification or the de-amplification they do is their speech, aren't they, in doing it, then playing a part that, I guess, should the harm arise from some of that curational activity, wouldn't then pierce Section 230 immunity? That's where Justice Gorsuch seemed to be going, and he asked, I think in the summary I gave to my colleagues, he asked 20,000 questions to that. I think that's a really difficult question that the various courts around the country have been dealing with. It's also a tremendously fact-dependent question that is completely not going to be answerable by in this case. But I think it was at least a little bit more of an interesting academic question to raise during the argument. It really would be hard, I think, for it to play. It's more, I think, of a question: what you do is there something we write in this opinion that previews how we think about that issue in a future case?
Lawrence and Vera, over to you. Any specific thoughts or observations on the Section 230 question and its implications?
Well, yeah, I think David hit it right on the head. Some of this, I think, comes from particularly Justice Thomas and Alito to a certain extent. Their concern with this idea that censoring user speech is somehow protected by the First Amendment. And, they kept going back to this idea, well, what do you mean? The First Amendment isn't designed to protect censorship of speech. It's designed to protect expression of speech. But that's not actually true when you get into the nuances. There's First Amendment right to curate and to identify which is more important, less important. And so it's a broad rainbow of different rights that can include, de-amplification and termination, as well as promotion of speech. But both of those justices, have a concern with Section 230 allowing this kind of private censorship. And so they dismissed it as, oh, you're just calling it content moderation, but it's really censorship, and try to push back on this idea that there could be possibly a First Amendment right to censor speech in the abstract. Justice Roberts kept coming back and saying, well, remember, this is a private company and only the government can, quote, censor speech to the extent that it would be a violation of the First Amendment. So I think he brought them back around to reality on a couple of those comments, but I think that's largely where some of this 230 discussion is coming from, with their concern over the ability to censor speech by a private platform.
And Vera, over to you.
I think those were great answers. I have very little to add, but I think that, yes, it is helpful to remember that Section 230 and the First Amendment are different things. There are ways in which Section 230 could play a role. I think David pointed it out well, both with the not very thoughtful approach and then the nuanced approach, but really the two questions are different.
Absolutely. Okay, so we're going to go ahead and turn to some audience questions. Please feel free to add questions using the Q&A feature below. I know there was a couple in the chat, so I will ask those after the Q&A type questions, but let me go ahead and pull up the Q&A. So starting off with this first question, what about the transparency mandate part of these cases? Did the justices ignore that aspect, or could we glean anything from the argument about how they might be thinking about the transparency mandates? I think this is an excellent question, up for grabs of the panelists here.
I can give it a shot. I was a bit surprised it didn't come up at all. And I think part of that might be that the full breadth of the transparency mandates of the laws was not before the court. There was only the very, very specific aspect. And the court really only talked about it when it talked about burden. And then they really started talking about the evidentiary record for burden. So but it's true. I don't think the court was really gave any hint about what legal tests they would apply to it, which is hotly disputed in the briefs. I thought they might ask the Solicitor General about it, because it was the SG who suggested, and they followed the suggestion, that they actually, to the extent they considered the transparency mandate, that it was the one identified by the Solicitor General, but they didn't. So I don't know if I do think that there was a lot of the justice seemed they're trying to be very careful about not writing something that's going to be too broad here. And I think maybe one of the things they want to preserve are some of these or less censorial avenues. So but I don't know that we heard enough to know which way they're going to go with that.
I tend to agree as well with that. Moving to the next question, again, up for grabs. Is it actually reasonable to think of email and direct messaging as common carrier-like? For example, Gmail has been advertised as curating messages, threading improved spam filtering, etc., for 20 years now. A commercial email provider isn't the post office. It's the post office plus a mailroom staff and a secretary. I tend to agree with this analysis as well. I thought the court kind of glossed over. I mean, technically, this wasn't exactly briefed by the Texas and Florida attorneys, but I kind of tend to agree as well. Email, there is a filtering aspect to it. Direct messaging, I think, has some different implications. But anyone who wants to take that? Well,
I can offer some initial thoughts. This illustrates why this is a novel case and why we're dealing with services that haven't been evaluated before. Email is not the telegram. It's not just end-to-end transmission and receipt. It's to a degree curation and display and filtering and a lot of other services bundled in. I think the court did not have a great record in terms of all of the email and other services that are offered by these platforms. So I think they were a bit hesitant to get into the details of that. This does go back to the interest in vetting the argument on common carriers and making sure they understood it, and if they're going to reject that they have a sufficient logical, factual, and legal basis to do so. But it's a really important point. Email is not just sending and receiving anymore. It's a whole host of services, and it's important that the court understand it and get it right.
And I'll leave that open in case anybody else wanted to chime in. Excellent. Okay, so please feel free, folks. I think we're done with the questions there for now. Please continue to feel free putting in questions in the Q&A. If not, I've got a few more I can keep grilling you all on. Justice Sotomayor seemed to be more skeptical of the state's common carrier arguments. I think a lot of the different justices had some skepticism as well. Do you think that this is a good signal? Again, to me, I figured, I'm cautiously optimistic, and this is going to go the way that, I think we're all looking forward to it going. Any reactions to, or any specific reactions to the way in which the justices sort of went down a line of questioning on common carriage? And I will start with Vera. Yeah.
I unmuted, so thank you. I think that my favorite version, I think it was Justice Kagan who basically honed in on the point that the reason that these laws were passed was because platforms are moderating and are expressing a view and are choosing what appears on their platforms, and that legislators don't like the choices they're making. So to me, that really kind of gives the lie to the whole idea that they're common carriers and just passive conduits that aren't engaging in any of their own expression. These laws were passed precisely because they are doing something. They are making spaces for speech that they like, and legislators don't like the choices that they're making.
There was a discussion throughout, it came up a couple times, about kids' safety. And as you all know, that's been a major topic for the past years. NetChoice has exhaustively some other cases on kids' online safety. Paul Clement had brought up, if you are in favor of kids' online safety, then you will vote to affirm the preliminary injunction. I'd love to hear, I'll start with David. What is the connection between these kids' online safety, the kids' online safety effort and the laws that are being enacted today, and the NetChoice cases up at the Supreme Court?
Well, the most direct connection is that under the Florida and Texas, well, let's just take them separately. Under Texas, which forbids the platforms from considering a viewpoint, whether expressed on or off the platform, in making content moderation decisions, that would mean that if they, and one of the examples that came up with there, if there would be that if they would decide, to allow anti-eating disorder or anti-body image harm speech, they would have to allow, speech proponents to speak as well. They would not be allowed. So that the type of child safety measure they might take in terms of trying to limit that type of harmful speech, which is just two examples of some of the speech that gets mentioned as a common harm, especially for young women on social media, that they wouldn't be able to do that. Texas is responsible. You could just have them and didn't talk about them at all, right? Which again doesn't seem to be an adequate measure if you're actually trying to promote safety and instead of sort of passively avoiding a harm. And so that's one of the ways. But and I think, and then with Florida, where you have to sort of guarantee a platform towards certain speakers, whether they're these very broadly defined journalistic enterprises or candidates for office, it would say that no matter what those people were saying that was harmful to children, you had to let them speak. So I think that's the application with this specific laws. More broadly, and I actually think much more importantly, and I think this is where Paul Clement was going, is that if you if you don't, if you find that sites do not have a First Amendment right to curate their sites, then there could be plenty of other legislation that can even more directly hamper child safety efforts. So if there's a state that disagrees with whether it is information about reproductive rights or gender affirming care, or name it, then, or vaccines, or, whatever, vaccine mandates in schools, whatever, that you could, there'd be those efforts, if a platform decided, hey, we don't want that, we think that's harmful, then a ruling that a platform did not have a First Amendment right to either exclude those or to promote other points of view would be severely hampered.
I think that makes sense. Going off of the social media kids legislation and the litigation that's followed, there's kind of been this discussion or thread that these laws don't regulate, expressive conduct, they regulate non-expressive conduct. We kind of started to hear that a little bit when we got to the algorithms discussion with the court today. It seemed like, and I think it was Justice Thomas who had pointed out, if content moderation is done through quote unquote neutral algorithms, does that somehow undermine the editorial discretion rights of that company? In other words, if there's not a human that is analyzing each and every content decision, then are the companies really engaging in editorial discretion? Lawrence, I'm going to throw that over to you.
Yeah, it's a fascinating question, and there's some intersection between these issues and what the Copyright Office is dealing with currently in connection with AI, and the extent to which a human being has to be responsible for creating artistic expression for it to be copyrightable. And it's the same kind of issue here. If the First Amendment rights emanate from a human being curating and managing the decisions on how the feed is displayed and how the speech is oriented to the user, then at what point do you lose that? At one point, is this simply a machine making decisions with no human input, and therefore there can be no First Amendment rights, since machines don't have First Amendment rights? And we're obviously at a point where this is all extremely new. They got into a little bit of the machine learning, and there could come a point where no human being is even putting the inputs into the algorithm for it to make the decisions, that it just has simply learned over time what to do on its own. I think it's an abstract question. I don't know that it's one that has to be answered here, because we're currently at a point where the algorithms are created by human beings, they're coded by human beings. Yes, there is some machine learning, there's some AI aspects that will be more prominent, I suspect, in the future. But as of right now, it's not an issue I think that they need to focus on in making the decision on the First Amendment rights of the editorial functions of the platforms.
Plus, I mean, these at the end of the day, these algorithms are, whether they're using AI or not, they're programmed by the humans who are programming them to actually enforce content guidelines that they came up with. So I think there's definitely still sort of an editorial aspect there as well. This is a question from the audience, and also, again, remember, you all can feel free to put them in the little Q&A box as well. Is there significance to why Justice Alito asked the Biden administration, when a social media company throttles a view, that shouldn't be described as censorship rather than content moderation? Is he trying to signal something to supporters of these laws? Up for grabs, whoever wants to take it.
Oh, when I first started doing free speech work, and I started doing public speaking on it, one of the things I quickly decided was I was never going to use the word censorship, because it just meant something completely different to people, and it never had the legal significance that anybody thought it did. And I used to start giving speeches, and I would just call it broccoli. I called anytime somebody would suppress someone's speech broccoli. And I had that flashback to that moment during the argument when they were like, isn't content moderation just another word for censorship? It was like, yeah, sure, but it's just not censorship by the government. So and so I that, with the way, I thought it was odd that it came from Alito at that point. And and I wasn't quite sure who he would, if he was trying to trap somebody, or not. I do think that generally most of the bench seemed to understand the state action issue, that whether you call it censorship or not, when we're talking about First Amendment violations, we're looking at whether the government is imposing the speech restriction and not whether the platforms are.
And David, to follow up on that, if it were the case that the government, there was some sort of coercion, or the government had sort of a heavier hand in the content moderation aspects, what does that mean for the companies? I mean, we know that the government is restricted. Does it then necessarily follow that the companies might be acting as state actors?
Well, I refer you to a blog post I published on EFF.org a while ago that talks about sort of when I think the companies might cross, when by working jointly with the government, the platforms themselves might be considered state action, which goes through the joint action and part of the state action doctrine, which is in no way a crystal clear doctrine. And so I, rather than try and remember what I said there, but I think you do have to really look for where the company in that situation is really very willfully turning over its editorial decision-making process to the government, as opposed to the situation, which is what we're going to see in the Murthy case, where the question is, did the government unwillingly seize, or unwilling to the platforms seize the editorial decision-making process?
And I'll add that EFF's post on this was very well done. So thank you. Going back to, okay, we have two more audience questions here. Excellent. First one, the text of the Texas law seemed very clear to me that it forbids geofencing, but I gather from the online commentary that Texas argued that companies could choose to leave after all. How did they square that circle? Same question on my side. In fact, I called it out on Twitter. I said the Texas attorney is lying to the court. It is very clear that it says that they cannot exit. What say you, esteemed panel?
It reminds me, when the government is defending a law, it's always very narrow and easy to comply with. But when they're enforcing the law, then all of a sudden it's these broad conspiracies and broad charges that they bring. It was a little bit of tap dancing, I think, by the Texas AG. It looked bad that Texas was saying that you can't leave and you have to stay and comply with all this. So he came up with an analysis that only if you first did business with the user that they have to stay, but you could decide from the beginning not to do business. It didn't really even understand, what the compliance obligation would be under his analysis. But it certainly seemed by the face of the statute that you cannot discriminate based on the geographic location of a user, and that would inherently mean that you can't discriminate against all Texas users as well. So I think it was a real problem point for the Texas AG to try to defend.
I absolutely agree, and I actually added as well, to me it seemed like Texas was selling out their constituents, just basically saying, no, of course you can leave, you can exit. They'd rather let them exit than actually embrace editorial decision-making. So excellent question. Next question we have on the list here. Did any justice take a position or seem to take a position that surprised you or wasn't what you expected? And I'm going to say that's a good question for everyone here. So Vera, I will start with you. What surprised you, something you weren't expecting?
I guess some of it was the policy nature of some of the discussion rather than the focus on doctrine. I think this goes to some of what David was talking about with the relevance of the term censorship. To me, some of it seemed more like a conversation I would expect out in public or maybe on the legislative floor, and not necessarily engaging with doctrine. I don't think that was the overall tenor of the conversation at all. I think David and Lawrence are right that it seemed to me that the justices understood the actual doctrinal questions in front of them, but that was surprising to me.
Vera, I agree with you. I had the same sort of thought, and I was actually thinking, do you think the amicus briefs might have been kind of the contributing factor to why we went so far down the policy rabbit hole?
It's possible. I mean, I think it's interesting the ways in which social media seems to scramble people's brains on this front.
That's a great way to put that. David, thoughts? What surprised you?
I was surprised with how many of the justices seemed hung up on the posture of the Florida litigation in terms of the questioning the propriety of the facial challenge and seeming to be, feel like that the record in front of them was incomplete and that they might not be able to. I was very surprised by that. And I was surprised by it by those who I think ultimately who I think ultimately would strike down the law, as much as I was surprised by those who I think would want to uphold the law, that they wouldn't look for a substantive hook to uphold the law and would look for a procedural hook, which again, I think it's just going to bring the issue back to them. And when the argument started out, I thought maybe this was just Justice Thomas, who I wouldn't be surprised doing. But then at some point, it really picked up to almost everybody, except for maybe Kavanaugh, who seemed perfectly happy to strike down the laws on the current record. Everyone. So I was surprised how much stamina that concern had throughout the argument. And then, I was completely not surprised. In fact, someone asked me last night what of the things I thought might happen that might surprise people. And I said, I think Justice Jackson is going to be very concerned about wanting to make sure the public accommodations laws were preserved and that they wouldn't say anything bad about public accommodations laws. What I was surprised about was how much she connected that to the procedural posture, to the idea that if there's a facial challenge, it is a facial challenge to dangerous or public accommodations laws, and would be okay with these restrictions on different functions instead of the ones that are at issue in front of the court.
I was really happy to see that got cleared up as well. I know I believe it was the Texas and I think Florida who came back later in briefings and had tried to frame this as like a civil rights discrimination case, which is rich for a lot of reasons. But, it was good that there was at least a split on the difference between the civil rights discrimination aspects, which would be more speaker-based discrimination, versus discriminating on the actual message. And I thought that point came across really clear. Lawrence, over to you. Same thing. What surprised you?
I was going to say the same thing that David mentioned about the focus on the procedural posture, and also the discussion of how can we send this back to the trial court, kept coming up over and over again, and discussions about what the contours of the injunction would look like as if they were actually deciding or thinking about deciding to send this back before rendering a decision. The case seems so ripe for invalidation on First Amendment grounds of both the Texas and Florida laws, that I thought there would be more of an appetite to cut through that and just focus on the constitutional questions, the level of scrutiny, the typical things that you would see in a First Amendment case. But it suggests that there is at least some potential that this might not be the last stop for the case, and it could come back to the Supreme Court after further factual development. And as far as other things, I was a little surprised about the discussion of censorship by private companies and how that wasn't obviously just not First Amendment triggering, and then also the discussion of 230 and trying to weave that in over and over again. So those were the big three for me.
I share all of these surprises as well. I was also surprised we didn't really get in the weeds with the transparency. I think surprised and a little bit disappointed. Moving on from there, I think what would be really helpful for this group specifically, I've gotten a lot of questions as to what are the options on the table. We heard a lot of discussion about facial versus as applied challenges. We heard vacate and remand could be options. What can you lay out the options here for the court? I mean, they can affirm the PI. They could, could they split the baby here with both laws? Help sort of lay out the types of options that this court has with this specific decision. And I'll go to anybody who wants to take that.
I mean, I do think that you're right that I won't take all of the options, but I think just answering your last question in terms of splitting the baby, I do think it's true that there are two different cases and two different laws at issue. And we also heard that there's, the scope of the injunction is different in the two cases. And so the courts certainly could dispose of the two cases in different ways, reaching the merits in one, not reaching it in the other, for example.
David, you went off mute there. I want to give you an opportunity.
Yeah, no, just really, I agree with Vera. I just, these are both just preliminary injunctions. So the most the court can do is uphold the preliminary injunction. We're not going to see the court strike down the laws. Now, they could write an opinion in such a way that effectively strikes down the laws, but the most they're going to do is uphold a preliminary injunction. And they're always, and with each case, you have the option to send it back for further, or to hint at what further proceedings they think might be important to change their minds. Now, I do think with Florida, and again, I was trying to sort of, you try and guess and count votes as you're listening to these things. Are there 5 votes to do something less than affirm the preliminary injunction and send this back in some way where maybe they stay the enforcer of the statute while these other questions are answered? I don't know. I think it's really messy. I do think they asked this question. I think both Justice Barrett and Justice Jackson asked this question of the Solicitor General, like, what can we do? And the option that the Solicitor General was trying to brainstorm was, uphold the preliminary injunctions, but remand for proceedings on certain, or to further develop the factual record, or to consider issues that weren't before the court, or things like that. So I don't know if there's enough votes for something like that.
Thank you both. I think that really helps clarify sort of the procedural posture here as well. We have another question from the audience, and I actually think this is a good one for all panelists and one that's worth ending on. Are we going to get an opinion with caveats and hypotheticals that just inspires more creative regulations, or do you think we'll get a more decisive ruling here? Is tech regulation going to be state legislatures taking big swings and haphazardly connecting, and SCOTUS being too hesitant to stop the wild attempts? David, I'll start with you, and we'll just go in our usual order.
Oh gosh, I always try not to predict, but I don't think I think it's really unlikely that we'll get a ruling that will stop all state efforts to regulate the internet. I think we will, a ruling that upholds the First Amendment rights of platforms to curate the compilation of user data will go a long way towards intermediate scrutiny being a starting point for future regulations. And then I think we'll see a lot of litigation over whether various state efforts to regulate the internet are going to be content-based and going to be subject to strict scrutiny, or whether they're content neutral or content agnostic, or whatever legislators like to call them now, and should be subject to intermediate scrutiny. So I think that's probably the most likely path for looking at future legislation.
Lawrence, thoughts on this one?
Yeah, I think that's right. I mean, there was even some discussion during the arguments about if there was a ruling on the PI and it gave some instructions, would Florida, for example, go back and try to pass a more narrowly crafted statute in the meantime, which would, potentially moot the case and create a new law to challenge and, bring up on, and then there could potentially arguments about mootness and so forth. But the states are not going to stop trying to regulate the internet, and they're not going to stop trying to regulate social media in particular. It's a hot topic, and there's a lot of emotion involved and a lot of political sides being taken. And so fortunately, we've got this case. It tees up the issues in a way I think that the court could set some guidelines that would potentially stop a lot of the unnecessary legislation and unconstitutional provisions in the legislation and the resulting litigation. Hopefully that's what we'll end up with. And I think it was a very interesting day of arguments.
Yeah, and I'll note as well, I mean, Florida did just pass, literally a couple days ago, HB 1, which would require certain restrictions for kids' access to online content. So even that seems sort of out of line with the current Florida law. But Vera, over to you for closing thoughts on this, just this last question. Clean it up for us.
Yeah, I mean, if I had my choice, it would be a very clear opinion that stated the law and made it easy if legislatures choose to pass laws, even if they know they are unconstitutional, to then just quickly challenge those laws. What the court will actually do, I'm not a pundit, I can't say, but I look forward to reading the opinion.
Panelists, thank you so much for your time. I know it's been a really long day. David, you were like in court. So just really appreciate your thoughts and insight here. Incredibly helpful. And we hope to have you back when we are having another inevitable conversation about these cases.